Does child support ever go down? In Utah, yes, it can. There are several situations in which child support is or can be reduced. Child support for a minor child ends for that child once whichever of the following events occurs later. A, the child has reached the age of 18 years, thus becoming an adult and no longer a minor child. Or B, the normal and expected date of his or her high school graduation. Note that the child does not have to graduate from high school as a condition of child support ending for that child. So you have to be 18 and your graduation date has come and gone, or your graduation date comes and goes and then you turn 18. At that point, child support ends. Child support can also end before the child reaching the age of 18 or the child's normal and expected date of high school graduation, in the event the child marries before reaching the age of 18 and normal and expected date of high school graduation. Child support can also terminate in the event the child becomes a member of the Armed Forces of the United States of America before reaching the age of 18 or the child's normal and expected date of his or her high school graduation. That's also in 78B 12-219 subsection 1. Child support can also terminate in the event the child is legally emancipated in accordance with the process of emancipation prescribed in Utah Code section 78A in Chapter 6. If a child support order has not been issued or modified within the previous 3 years, a motion can be made to adjust the amount of child support order. That's in 78B-12-210 subsection 8, kind of a cost of living adjustment after 3 years, if assuming the parent or both parents' incomes have changed. They can do this if A, based upon the parent's respective current incomes, there is a difference between the payor's ordered support amount and the payor's support amount that would be required under the guidelines. And B, if the difference is 10% or more. C, the difference is not of a temporary nature. And D, the order adjusting the payor's ordered support amount does not deviate from the child support calculation guidelines. If there has been a substantial change in circumstances, regardless of how much time has passed, that can also be a basis for a modification. See section 78B-12-210, subsection 9. For purposes of subsection 9, a substantial change in circumstances may include A, material changes in child custody, B, material changes in the relative wealth or assets of the parties, C, material changes of 30% or more in the income of a parent, D, material changes in the employment potential and ability of a parent to earn, E, material changes in the medical needs of a child, or F, material changes in the legal responsibilities of either parent for the support of others. If a substantial change has occurred, then the court determines whether the change results in a difference of 15% or more between the payor's ordered support amount and the payor's support amount that would be required under the child support guidelines. And if it does, then the court will adjust the payor's ordered support amount to that which is provided in the guidelines if 1. There is a difference of 15% or more, and 2. The difference is not of a temporary nature. Those are the ways child support can go down in the state of Utah.